So for those that I don't know, my name is Jonathan Holfinger. I am a real estate lawyer and owners of Northwest Title and partners in the Holfinger-Stevenson law firm. And this environment today for the class is a little bit different than most of the classes I teach. It's a little bit more auditorium style, but I don't want that to discourage you guys from asking questions. I think that in every class that I teach, it's always the best class when we have audience participation, because you all perk up when someone asks a question because you've probably had a similar situation and you're curious, what my thoughts are, that sort of thing. Sure, I can go through a PowerPoint, I can lecture from slides, but that's kind of boring. So we don't want to do that for a full 3 hours. Obviously, this is core law. You're here to get your core credits, but I want to make it as interesting as possible as we go through this. So please don't hesitate. Raise your hand, ask the question. I'm also recording this class today, so the audio runs through my microphone, so I'm probably going to repeat your question for everybody to hear, and so that we can get it on our recording as well. So I've done a brief outline that if you want to take notes on, if you don't have, we have those up front. But basically it kind of covers a loose timeline of what we're going to hit on today. But as most of my classes do, they end up taking tangents based on your questions. So if you have trouble hearing me in the back or whatever, we have plenty of seats down here in the front. We don't have a microphone from the library, so I've got to just speak loudly and hopefully you all can hear me. All right, so a little bit of background about me and about the law firm and all that. I started Arrow Title Agency back in 2005 in my third year out of law school. I'm now in my 14th year practicing law. I've chosen to focus on real estate. It kind of branches out into some other things, but for the most part, we do real estate transactional work. So I'm not a litigator. I don't take cases to court. Obviously, we work directly with real estate agents, buyers and sellers. We don't want to sue them also. So we prevent the lawsuit. We try to help people through that process. And what I'm going to talk to you about today are things that I think you should know about as real estate agents, things that I've come across in my practice, and things that I think are commonly misunderstood. I find that you've got to understand the foundation before you can really truly understand how the details fit together. So we'll talk a little bit about the background of everything, why it is the way it is. And then, we'll get into agency, your duties as a real estate agent, ways that you can get in trouble with dual agency. And also at the third hour, we're going to talk about interests in real property. I always find that those are most interesting outside of Columbus, where you don't have a bunch of subdivisions. But hopefully you guys have had some experience dealing with access rights, easements, different types of liens. We'll touch on all sorts of those things as we go through it today. So our companies, basically, we operate in mostly central Ohio, southern Ohio, eastern Ohio, and northern Kentucky. So we have 11 offices from Florence up to Columbus, out to St. Clairsville, and we just hired a West Virginia attorney, so perhaps we'll have an office in Wheeling at some point later this year. And so I tell you that to let you know that our breadth of experience has to do with a lot of different real estate issues. So when we're talking about core law, we're talking about contracts, but we're talking about things that we see on a day-to-day basis in our business, and I want to share with you some of those things. Also, just to kind of give you a better understanding of the foundation of the law, let's just talk big picture here. Things you might have learned when you were studying to get your license, but maybe need a little bit of a refresher on. We're talking about how does the law apply to what you do every day, right? You may hear lawyers throw around terms, and so I want to kind of demystify some of that. So let's talk about statutory law versus common law. All right, everybody is aware that there are laws that are written. Those are called statutes, right? So how many people here, by a show of hands, have ever looked up the Ohio Revised Code online? Okay, maybe a third of you guys have done that. If you haven't ever looked up the Ohio Revised Code, it's very easy. Just Google it. You'll find it. And then you can look up all sorts of things related to your real estate practice and also related to real property in general and what you can and can't do. So that's where the legislature has decided what the laws are going to be. Those are often written by interested parties that then the legislators approve and pass into law. And that is different than what happens in a courtroom. Okay, so when we're talking about common law, it sort of encompasses the idea that there are these core concepts to what we do that go back in time, well before the United States was even established. So going back to the Magna Carta and English common law. And so these concepts such as are we in a contract or not, are not found in the Ohio Revised Code. Those are established over time and interpreted by courts, by judges. And so as the body of law changes with judicial opinions, basically the common law evolves and adapts and becomes more detailed and more specific as more fact patterns arise and make it through the court system. So when we're talking about common law, we're basically referring to these concepts and then how they're interpreted by various judges at different levels of the courts. And so in order to understand how that works, you kind of have to understand a little bit about the court systems. So there's federal and there's state. And under the federal system, you've got the Supreme Court. Obviously, you've heard in the news, Justice Scalia passing away. He was one of those. Those are appointed by the president. You've got 12 courts of appeals for our 50 states. And then you have 94 district courts. And so we've got the Southern District of Ohio. We've got a court right here in Columbus. And then that goes up to the Court of Appeals and eventually to the Supreme Court. But people don't get to just choose to take it to the Supreme Court. The Supreme Court has to grant you permission to take your case. It's called certiorari. So it's not something that you can just say, hey, I want to take this all the way to the Supreme Court. They may decline to take the case. Why? Because the purpose of the higher courts, whether it's state level or federal, is to decide what happens when you have courts with conflicting interpretations of the law. So when you have conflicting cases in different levels of courts of appeals, the Supreme Court of the state or of the federal government would then grant certiorari to take a case to decide something that is split amongst the lower courts. So in the state court system, what matters to you guys most importantly is our common pleas court system. And in every state, the courts are different. So you can't take this over to Michigan and apply the same rules. But in Ohio, we have 88 courts of common pleas. We have 122 municipal courts. We've got 44 county courts and 428 mayor's courts. And so common pleas are the courts that are generally going to hear real estate contract disputes where the amount in controversy has to do with the value of the real estate. You're going to find those generally there. If they're small matters, fights over earnest money or something where they're only wanting $15,000 or less, they can be in municipal court. If it's $3,000 or less, they can be in small claims court. And if you're in small claims, which is a division of municipal courts, you don't have to be represented by an attorney, and they are very lax about the rules of civil procedure. So it's much easier for people to sue over $3,000 or less if they go into these small claims courts. So any questions about the court system? Obviously I could give you a lot more than just what I did, but feel free to jump in with any questions as I go. So let's talk big picture again when we're talking about the United States Constitution. It specifically deals with what you do in your job through Article 1, the 5th Amendment, and the 14th Amendment. Because we're talking about Article 1 of the Constitution says we all have the liberty to contract with each other. Eminent domain has to deal with the government's right to take your property. Okay, that's the takings clause that's found in the 5th Amendment. And generally speaking, a government can't just take your property, right? You have certain rights that are protected by the Constitution. And so the concept of eminent domain has to do with basically when the government needs to take a particular person's property for public benefit, they have to provide just compensation, and they can't just do it because they want to put it in a new mall for commercial development. Usually it has to do with transportation or some other public benefit where the greater good will be served. And under due process of law, how many people here by show of hands know what we mean by due process? Have you heard of that term? Do you know what it means? Anybody? Couple people? Okay. So in general, for those that aren't familiar with that, is that it's your right to defend yourself in court, more or less. That everybody has the opportunity to go to court to provide their version of the story and be heard. So when someone sues someone else, all right, it's not just hey, I'm going to file it over here, and the duty is on you to know that, right? You have to be served, and then you have an opportunity to present your defense. And so the process of serving someone and allowing them to be heard and allowing them to have a jury trial if they so desire, all of that is part of this concept of due process. All right, there are federal statutes, federal laws that are written that pertain to what you do that you probably don't even realize, such as the Do Not Call Act, the Junk Fax Prevention Act, and the Can Spam Act. All of those apply to your marketing attempts. So if you're out there emailing your client list, you still have to comply with the Can Spam Act. And if you're not, you're in violation of a federal law. Somebody could take umbrage with that and potentially make trouble for you. Yes, question?
Like, as a realtor and all these different companies get a hold of your name,
Mm-hmm.
I mean, I'm constantly getting unsolicited emails, so.
Right. Yeah, basically, when they are doing things that are unsolicited, the question is, how did they get your email, right? Because it could have been something where they purchased a list because at some point you provided it to somebody and there wasn't a restriction on them selling it. And so, but what the Can Spam Act does say is that you must notify the recipient that they have the right to opt out, and then if they choose to opt out, that you have to remove them from your mailing list. So if I hate that because I get a lot of email and it comes in and there's no way to unsubscribe. So if you reply and say, please unsubscribe me from this mailing list, and they don't, then they're potentially in violation of this. Also, there are rules as far as if you are just scouring for information and you're not obtaining it from a public source, you might be in violation, but I don't think you guys are going to run afoul of that. So, other things that apply to you. USA Patriot Act. Show of hands, how many people here know what the Patriot Act is and knows what it means? Okay, a handful of you. You understand that we have to collect identification of everybody in a real estate transaction. And why? To make sure, more or less, they're not a terrorist. We have to make sure that they are not on the specially designated nationals list that the government keeps, because if they are, they may not be able to participate in a real estate transaction. We may have to notify the FBI that they're trying to do that. And so that's an important act that came about after 9/11. RESPA, I think everybody here has heard of RESPA, the Real Estate Settlement Procedures Act. That's a federal law. Truth in Lending Act and Regulation Z. So we've got RESPA, we've got TILA, Regulation Z, the Mortgage Reform Anti-Predatory Lending Act. All these things have been changed recently. We've all heard of TRID, right? This is the stuff we're talking about. And so these are all federal laws that directly affect how you close your real estate transactions. And also fair housing law. We have a specific class on that actually that talks about discrimination in housing and whatnot. That's also a core class. You guys have to stay current on that. And then any house built prior to 1978, you've got to give the lead-based paint form. And so that is a federal mandate through federal statute. All right, what types of state and local laws apply to what you do? Well, your broker's license and your agent's license. Those are all state by state. It seems kind of common sense, you're licensed in Ohio, but just keep in mind that the rules about licensure apply differently if you're in a different state. So it's not the same everywhere, and just because you're licensed in Ohio doesn't mean you can represent an agent or represent a buyer or seller in another state and expect to get paid a commission. I just had this question come into me yesterday, and the question was from an agent who said, hey, I just got an offer on a Columbus property from a real estate agent in Chicago using a Board of Realtors Chicago's contract, right? Not the Columbus contract, they were using a Chicago contract. And the agent was inquiring about what the commission split will be with this agent. And when looked up, this realtor out of Chicago is not licensed in Ohio. And the realtor was asking me, what do I do? And I more or less said, well, calling the Department of Commerce might be a good first step, verifying that you're not running afoul of that. Secondly, you might want to touch base with your broker on this. But overall, if that person is not licensed in Ohio, then they are not eligible to receive commission in Ohio. Because the whole point of having a license is that you're authorized to get paid to do what you do. And so, in general, no, that agent is not entitled to a commission. Now, I see this sort of thing happen, especially in commercial transactions, where a lot of times people aren't too worried about those license laws, but they are state by state, and you must be licensed in the state you expect to get a commission on. All right, other things. Real estate conveyance statutes. So the actual way that you convey real estate or place a lien on real estate is different between states. So a deed is a simple example. In Ohio, we have specific language that has to go into a deed. All right, it has to have the word grant, and there are several elements of the deed. You go down to Kentucky, and it's different wording, and guess what? The buyer also has to sign the deed in Kentucky. That'd be kind of weird in Ohio, right? Buyers aren't signing deeds, only sellers are. But in Kentucky they are. In West Virginia, they don't have mortgages. They have deeds of trust. So again, everything is state specific when it comes to conveyancing and real estate law. So something that when you're dealing with a lawyer, you obviously want to make sure they're licensed in the state that the property exists in, because otherwise they're not going to have any clue what they're doing. Probate statutes. So when someone dies owning real estate, what happens? Well, we need to obviously understand probate law, because that's going to dictate what's going to happen with that property if they haven't properly done the things they need to do to avoid probate. Statutes of descent and distribution are in place to decide who gets the property when they don't have a will. And then things like contract law and fraud are classic examples of common law, because that has a very long history. So the 5 elements of contract formation, for example, are based in common law, and the interpretations of that common law are going to be different in every state, right? Because the states have different court systems. So a court decision in Kentucky is not going to be, authoritative here in Ohio. It might be persuasive. I mean, maybe a lawyer could use that case as an example to argue it in front of a judge here in Ohio, but it's not going to mean that the judge here has to decide the same way, because it has no authority across states. So you end up with different variations of applicability depending on where you are. And then we have local laws, right? So different things that matter. If you do any business outside of Franklin County and you're dealing with any sorts of meets and bounds properties that are not in a subdivision lot, transfer restrictions become an issue. And we often are dealing with the fact that somebody goes to sell property, the realtors have engaged everyone, they think they're good to go, and we do the title work and come back and tell them, you don't have a valid legal description, you're not going to be able to record it, and the seller, you're going to have to pay $2,000 to hire a surveyor to go get a new survey, because the local law says you can't convey this piece of property. In addition to that, obviously we might have insurability issues with it, but there are county standards for things like conveying real estate. Any questions about that? Yes?
I've seen more often on the auditor's website properties that are TOD. Mm-hmm. Is that a new popular trend, and what's the benefit of it? And is there a time frame that when the property is transferred before the recipient can sell it?
No. Okay. So the question is, what is the designation on the county auditor's website of TOD, and what does that mean? What is that all about? I'm going to give you a little preview of hour number 3, where we talk about interests in real property, talk about life estates, transfer on death. But I'll just tell you right now, TOD stands for transfer on death. And basically, the auditor's designation is kind of irrelevant to what the legal interest is, because only what's in the recorder's office really matters. But if they designate that, then you can envision what it's saying is that someone is going to be a transfer on death beneficiary. So if somebody dies, the property will automatically transfer to somebody else. However, those are revocable. So just because I'm giving someone a TOD designation today doesn't mean I can't change it next week. So the beneficiary has absolutely no rights in the property until that person dies. It's contingent on death, and it can be changed beforehand. So oftentimes I get the call that says, hey, I want to add my kid on title or whatever. They say, I want to add someone on title. And I say, really, why do you want to do that? And they say, I don't know, I was told by somebody I should do that. So this is what I need. Don't I need a quick deed or something like that? And I say, okay, well, no, it's not a quick deed. It's quit claim, but we don't want to do a deed. Why don't we do a transfer on death designation affidavit instead? And why don't we look at your will while we're at it? Because all of those things matter when it comes to conveying real estate. So there has to be sort of this estate planning conversation that needs to happen with your clients. You can't just say, oh, do a deed, because there's a lot of elements that come into play. We'll get more into that in the 3rd hour. All right, any other questions? Okay, so let's talk a little bit about litigation real quick, criminal versus civil. You guys all might find yourself in a lawsuit someday. Anyone can sue anybody for anything. Doesn't mean you did anything wrong. I've been sued And the basis of the lawsuit was that I was in a conspiracy to defraud a home buyer because the home buyer alleged there was black mold in the house. And somehow the attorney preparing the deed was a part of that conspiracy to defraud them. And of course, my title agency was named as a defendant in that lawsuit, along with the real estate agent, et cetera, et cetera. And the long and the short of that situation was we actually not only won the litigation, but we incurred $50,000 plus in defense of that because the opposing counsel was a real piece of work. And so this opposing counsel, who didn't want to resolve anything, because obviously it easily could have been, but he didn't want to. So our insurance company got our approval to move forward with seeking sanctions against opposing counsel, and as a result got a judgment against the opposing attorney for $62,000, which he couldn't pay, which he forfeited his law license because he didn't want to practice law anyway because he didn't like it, basically is what he said on the record. But in the meantime, he had filed all these motions and he made an appeal and all this kind of stuff when he lost, basically berating and insulting the judge. And the insurance defense counsel that we had basically said that it was the talk of their firm. They have a very large firm with offices in Cleveland, Columbus, Cincinnati, and some other cities. And they said, this is like the most egregious lawyerly conduct we've ever had. I can't believe this. You know, this is like a story we're all telling amongst ourselves at this firm. And I just thought it was ironic that I was a part of that. You know what I mean? It was just a crazy case. And we didn't do anything wrong. But I got sued. It lasted 3 years. We had to deal with it. So you guys might have to be in that same position someday, and understanding how this all works, what civil litigation is all about, might come in handy for you. So criminal is where a lawsuit is brought by the government. Civil is where a lawsuit is brought by an individual. And there are some minimum standards that individuals who hire lawyers, they must follow these standards. Lawyers have ethical conduct standards, which is why we won sanctions against that attorney for frivolous conduct, right? It wasn't a basis for a lawsuit. And he just kept at it and wouldn't, let it go. So he lost his license as a result of that. But in general, if somebody, might file pro se, right? They didn't hire a lawyer. And they're going to be given a lot of leeway when they file pro se. That's like your worst nightmare, basically, if you get sued by somebody pro se. It's going to cost you a lot of money because they do all sorts of crazy things that they find in law books in the law library, and your attorney's going to have to answer to all those things. So anyway, what's different about these two types of situations is that most people are familiar with criminal standards, right? They watch TV shows and they say, okay, the standard is that you're innocent until proven guilty, right? We've all heard of that. And that the prosecutor's got to prove the case beyond a reasonable doubt. But that's not how it works in civil litigation. So if you guys are involved in a lawsuit, hopefully it's not criminal, and you're going to be dealing with the fact that the standard is for a plaintiff to prove the case by a preponderance of the evidence. Okay, so it's a preponderance. It's not beyond a reasonable doubt. But basically, that plaintiff, if they do that, are going to be seeking either damages or an injunction. Right? An injunction would be like a court order to do something or to stop doing something, whereas damages are usually reduced to, compensatory damages or punitive damages, which are monetary amounts, right? So, they want to sue for breach of contract and they're asking for $25,000 as their damages, whereas they might want specific performance. Has anyone here ever heard of the term specific performance? Okay, good. A handful of you guys have. What we're talking about there is, let's say a seller breaches your real estate contract and the buyer says, I want that house. They file a lawsuit that says, court, you need to order the seller to give me the house. That's very rare. It's not generally going to happen in residential real estate transactions because the quality of the property is not necessarily unique enough to warrant the taking of property from someone. Okay, they're much more likely to say, no, we need to reduce this to a monetary compensation situation. It's only in like complex commercial transactions where the nature and character of the real estate is one of a kind. And it couldn't be, you can't put a price on it. There is no substitute. So in a house situation, there are plenty of substitutes. That's why courts don't do that. Okay, so civil litigation categories. We're talking about things that you could eventually end up in: family law, torts, and contracts. Those are the three main categories of civil litigation. So the substance of the lawsuit is going to be a breach of a contract, which could be like a written real estate contract. But it also could be you breaching your fiduciary duties as a real estate agent to your client or to your broker. That is also a breach of contract. Okay, you have a contractual obligation to do those sorts of things, and that would be found in contract law. Torts are sort of a sister claim to contracts, where you may say you were negligent in your fiduciary duties as well. So there's oftentimes an either-or situation where they're suing in contract, and if you don't find that we reached that, well then they were also negligent. You know what I mean? So we're going to win on either a tort or a contract claim. You can't have both. But then there's family law, which is also a class of civil litigation, divorces, and those sorts of things. In the United States and in Ohio, everybody has the right to a trial by jury. Okay, but keep in mind that juries, they don't know the law, so they can't decide whether or not something, should be, basically should be interpreted in a particular way that a bunch of attorneys would think is fair. So what do juries do? Well, juries are just fact finders, right? So they hear the testimony, they see the evidence, and they make decisions about what they think actually happened. So that's all they are, is fact finders. Whereas a judge is going to tell the jury through jury instructions, if you find the facts say this, then that means the law applies in this way, and they are going to, obviously side with one side or the other based on the applicability of the questions of law. So when there are questions of law, those must be decided by the judge. Only questions of fact are decided by a jury. And you don't have to have a jury trial. You can have just a judge trial only. So, but it's just your right to have a jury trial. And this applies for civil litigation as well. An example of this would basically, let me use example number 2 down here. Is a lease that has a term of 1.5 years valid if it's not in writing? Okay, and basically that is a question of law. How would a jury know the answer to that? You know what I mean? Half of you guys probably don't know the answer to that. So they don't need to answer that. And so a judge would basically be telling them, if you find that the landlord told the tenant that the lease was 1.5 years, then it would be unenforceable because the statute of fraud says it must be in writing. So that's kind of how that whole system fits together. So whenever I'm getting a call from one of you guys with a set of questions, right? You've got this crazy fact pattern. You're like, I don't know what to do. I'm going to ask questions. I'm going to want to know what the facts are, because the things that I'm going to be thinking are, how do we avoid going to court? And if we did end up in court, what would be the likely outcome? I told you in the beginning, I don't do litigation. I don't want to have to mess with that. I try to make sure that people stay out of court. But basically, when you call me after the fact, and I haven't been involved enough to prevent it, I'm going to tell you, well, the facts probably would say that your client would prevail. However, that doesn't mean they will. Okay, and that's sort of a key thing to understand, is that you don't know what's going to happen, and what that local judge, does he understand real estate law? Does his clerk understand real estate law? Are they going to be doing things correctly? Because there isn't just this one place that you can go look up what the laws are and it's common sense. No, it's very complicated. Like I said, common law has all these cases. So there's, 200 plus years of cases that would have to be researched and figured out and applied. And those are very lengthy, time-consuming. Legal research is just a long process. So a lot of times you get bad judges and bad decisions and all that. But I guess I would say, even if your client does win, collection is the next problem. So in general, when we're talking about litigation, I generally tell people, nobody really wins. Nobody's really ever happy. In the first few years out of law school, I was involved in some litigation, and it was just frustrating because, it never feels like there's any real good resolution, because even if they win, they got to pay the lawyer to do that, which is usually not cheap. And then if they have to collect, either the defendant doesn't have enough money to collect against, so they have this paper judgment that's not worth anything, or if they can collect, maybe they have to hire someone to do that, and that collection agency or collection lawyer might charge 33% of whatever they're going to get. And maybe they garnish the wages, but they're going to be receiving that payment over the next 10 years. So again, the idea here is, what I'm trying to convey to you is, going to court over something is not usually a good idea. So we need to make sure that we draft good contracts, that we've got everything, our ducks in a row ahead of time, and that we have good communication so that people don't get to that point where they think that's an easy out or an easy remedy, because it's just not. Most people think offer plus acceptance equals contract, which as a fundamental concept, those things are involved, but there are other things that are involved too. It's not just offer and acceptance, okay? So in general, I would say there are 5 elements to a valid contract. And more or less, this is like there's capacity, offer, acceptance, consideration, lawful purpose. Some people would say, well, contractual capacity is a defense, you know, and so it's not truly an element, whatever. That's sort of technical in nature. But what I would tell you, these are the 5 things you need to think about, okay? First is contractual capacity, the ability of the people that you're working with to even sign the contract in the first place. And that's something that you're going to be facing a lot. If you haven't already faced it, I'd be surprised. Second is the offer. There must be an affirmative offer made that is clear and definitive in its terms, which, lucky you all, you have standardized form offers, right? You just fill in the blanks. It's clear. You don't have to worry about, do you have a qualified offer? Does it meet the legal standard of an offer and all that kind of stuff? Acceptance. That is something that we'll get into a little bit here because it does affect what you do, and oftentimes there are errors made when trying to accept. Consideration isn't an issue for you in real estate because everybody's paying money for the real estate, and that is consideration, so it's usually not an issue. And then lawful purpose is not an issue in real estate because lawful purpose means that you can't have an enforceable contract for the sale of marijuana in Ohio because that's not legal, but maybe in Colorado or some other state where it is legal, maybe you would have an enforceable contract for the distribution of marijuana or something like that. So you just have to make sure that whatever the purpose of the contract is a legal purpose. And also in Ohio, there's another thing that you have to know, a 6th thing, statute of frauds. So how many people by a show of hands know the term statute of frauds? You know what it is? Okay. How many people know that a real estate contract must be in writing to be enforceable? Hopefully everybody raised their hand on that one. That's the statute of frauds. That's what we're talking about. Okay, so in Ohio, any contract that cannot be performed within 1 year must be in writing to be enforceable. Any sale of goods for more than $500 must be in writing. Any sale of personal property for more than $5,000 must be in writing. Marriage contracts, guarantees to pay the debt of another, any leases of longer than 1 year, and then in all caps, all contracts conveying an interest in real estate must be in writing to be enforceable. So I got a quiz for you. Keep you interested here. A little focused. All right. First one. Does a contract to sell a mobile home need to be in writing to be enforceable in a court of law? Okay, most everybody says yes. Okay, by a show of hands, how many people say yes? Okay, how many people say no? How many people say it depends? All right, I see some people raise their hand more than once, so maybe. All right, so the answer is it depends, and I heard the answer over here. It depends on what the price is, because I said a mobile home, so by definition I'm saying something that is not a permanent improvement yet. It is still mobile, and therefore it is personal property, and if it's more than $5,000, then it must be in writing to be enforceable. And honestly, I have done real estate transactions with mobile homes worth less than $5,000, and I have seen that is possible. They're more or less junked, but it can happen. So, next question. Does an agreement to represent a seller and list their real estate need to be in writing to be enforceable in a court of law? How many people say yes? How many people say no? How many people say, are you trying to trick me? Yeah. How many people say it depends? A couple people, all right. So the answer to this one might surprise most of you. The legal answer is no. Now, I'm not telling you not to put it in writing. I'll get into that in a minute. But it does not have to be in writing to be enforceable. What about if you represent a buyer? Okay, does an agreement to represent a buyer to buy real estate need to be in writing to be enforceable? How many people say yes? How many people say no? Most people say no. Anyone say it depends? Okay, the answer is also no. Because these two things are the exact same thing. And what is it? You are representing a consumer, okay? And that relationship is not a real estate contract, is it? That is your agency contract. That is your duty to the client as an agent. Whether it's the buyer or seller is irrelevant, okay? And so therefore, in neither case do you have to actually have a writing to be considered by the court as the agent of that consumer. Okay? So I'm telling you that because you have to be careful that even if you don't have a writing, you could be found to be engaging as someone's agent even though you didn't think you were. Because you have a professional license. And courts love to interpret things against the educated licensed person and in favor of the uneducated person that wouldn't know any better, right? An ordinary person, an ordinary reasonable person might have thought that your actions made them think that you represented them. And therefore, if they argued that in court and court agreed with them that those, well, trier of fact, maybe a jury would think, yeah, it makes sense. I think that that person was reasonable in their thought that you represented them. And your defense is, I didn't have it in writing. Doesn't matter. Doesn't matter if you had it in writing or not. You can still be their agent. So I tell you that as a practice pointer, that when you are, say, representing a seller, and you know you have a listing agreement, right? And you're like, I got it in writing. We've spelled it all out. And then you're working with some sort of buyer who's calling you, wants to see the house. You know, you've got to give them these disclosure forms to tell them if you represent them or not. This is why, okay? Because you need to tell them, I don't represent you. Because if you have these interactions, you may be found to represent them and you didn't think you were. So, email them, say, hey, I'm not your agent, blah, blah, blah. Just find ways to CYA. I have to do all that all the time, just like you do. As a lawyer, I have to be careful about who I represent, right? I get asked to prepare a deed. Who do I represent? You know what I mean? The contract says the seller, but I never talk to the seller. Title agency is the one who asks the lawyer to prepare the deed based on the contract. So, what is it? Well, if we don't have a real estate contract, I always have the parties sign a disclosure that says that I don't represent them and that my only job is to draft a document that is, executable and recordable and effective from that standpoint. But I'm not giving legal advice to the parties about whether or not it's a good idea to do the deed. So I'm not actually representing them. So you guys have to be careful in that kind of same vein, is that you have certain duties and you want to make sure that you convey to people when you're not their client just as much as when you are their client or when they are your client. All right. Any questions about that before I jump into capacity? Yes.
An example of why we would have to do that?
Of why you would want to cover yourself?
Yeah, well, no, why we would have to.
Why would you, when you say have to what?
Why would I have to write something to the client and say, I'm not your...
Okay, so the question is, why would you tell someone that you're not their agent? And what I'm saying is you shouldn't be doing it all the time. You should be doing it when the situation arises where you know they're not represented and you're not wanting to take on a dual agency role for some reasons I'm going to get into here in a little bit about maybe that's not a good idea. Maybe you shouldn't represent the buyer. Maybe you should just keep on the listing side and contact a lawyer for the lawyer to represent the buy side. You know what I mean?
I have a listing, a seller that tells me she doesn't want me to be a dual agent.
Yeah.
I need to let them...
Yeah, obviously you have disclosure forms that you have to provide identifying who you represent. And I'm just saying it's always a good idea to communicate that. You can verbally do it, but the other thing that you should probably be thinking about in your real estate practice is, certainly I told them that, but would they admit that I told them that? Maybe I should document it if the facts gave you pause to think about it. You know what I mean? If so, you shoot off an email. This is just to confirm our conversation over the phone to let you know that I only represent my client, which implies I don't represent you, and this is the next step in our transaction. You know what I mean? So I'm just saying it's a good idea to document things when there might be the potential for that misinterpretation by someone based on the facts.
Would work the same as long as we put it down.
Yeah, I just think that relying solely on a form sometimes can lead to misunderstandings. So in my practice, I would say you provide the form and you explain to them why you're giving them the form. You say, hey, just so you know, I'm not representing this transaction. Therefore, you should sign here to acknowledge that I'm only representing this person. You always want to make sure you're telling somebody something because it establishes trust. and it diminishes the likelihood that later they're not going to like you and they're going to come back and sue you, as you'll see from some case examples that I give about agents that got themselves in hot water, mostly due to the fact that the consumer didn't like the way the agent was communicating, and they kind of thought that the agent was too aloof and just not interested in explaining the process. So, okay, contractual capacity. So, the capacity is the legal ability to enter into a contract, and so you must be 18 years or older, and you must be mentally competent. And that is the one that I think all of you will be dealing with at some point if you haven't dealt with it already, is whether or not your client is mentally competent enough to sign the contract, aka sign the deed. If they can't sign a deed, they're not, able to sign the contract either. Question, yes?
As someone who's not a mental health professional, how exactly am I expected to quantify that?
Great question. So let me use example number 2 to help start that conversation, to illustrate the point is, and the question, just to repeat that, is I'm not a mental health professional, how would I be able to know if they're competent or not? Okay, Mary is elderly, she wants to sell her condo. The realtor has her enter into a contract to sell it to the Browns. The realtor tells the title company that Mary's going to move to seniors housing and needs care and help because her memory is bad and she's, her family says she's losing it, and that's why she's selling the house. So that is a factual scenario that now we have to ask the question. Now you have to do some due diligence, okay? And we got to find out, is she with it? So we could ask simple questions. What's the address of your property? Why do you want to sell it? What do you think your property's worth? I mean, you just ask basic questions that you would ask anybody else, and if they can answer them, well, then you shouldn't have any problem getting up on the stand and testifying that you felt that she was mentally competent. Does that make sense? Because more or less what that's all about is, if you think about what I said in litigation, is if that transaction goes bad, you're going to be called to the stand, okay, in a courtroom, and you're going to have to defend your actions. And the lawyer who might be cross-examining you would say, so what steps did you take to verify that she was competent to sign this? You know what I mean? And you'd have to say, well, I had a conversation with her about this and that, and you have to be able to defend it. So just, when there's a red flag, when there's a situation that might give you some concern, that's when you should make sure that you do a little bit of due diligence. And if you don't know what to do, you call a lawyer. Okay, that's the whole point of that, is if you're not sure, but you think something might be wrong, give a lawyer a call who knows something about these sorts of things, and they might be able to give you some free advice to say, well, you could do this or that. Now, the other situation I guess I would tell you about is you could also call the title company to say, hey, just so you know, this is what the family told me, but she's not getting current medical treatment. There hasn't been a diagnosed condition of dementia yet or anything like that. You talk to the title company, they may say, yeah, I don't think it's going to be an issue as long as she knows what she's doing when we close. So, I mean, we've gone to seniors housing to have people sign. They can still be competent, but be in a care facility. It's not indicative of competency. But it starts to get in that gray area where the notary might have a problem, and the title insurance company that's ensuring that it's a valid deed might end up with a problem as well. So, you're going to be on the front end of that. Here's another example. We had a situation a couple years back where, transaction was closing through my title company, and I think my transaction manager was working with the family, more or less, the son, of the woman who owned the property. Father had died and mother was left in title, and they were trying to sell it. And, it's not that unusual for us to deal with this, the children of somebody who's in title. So I don't think my employee thought much of it, but just said, hey, everybody's going to be at closing, schedule it. There was some communication there. But the lesson learned was that our employee never actually talked to the woman. And at the closing table, when she showed up, it was very clear to her that this woman was not competent because she was really not able to converse about anything. And when asked for ID, she couldn't provide it. It was being provided by the son. And it was sort of like all this stuff was being done for her. So then she's like, yeah, but I need to talk to the missus here and actually make sure she's good to go. And then, my employee came into my office and said, this woman does not know what's going on, doesn't know what day of the week it is. I had to go in there, ask a few questions, pull the realtor and the son aside and say, look, I'm sorry to tell you, but we cannot notarize these documents. We cannot move forward. These will be void. And so this transaction can't occur without a guardianship being filed. Okay? And of course they said, but what about a power of attorney? Can't we just do a power of attorney? And I sort of smiled and said, unfortunately, she can't sign a power of attorney right now either. That's not going to be enforceable. So we have to do a guardianship. That's a probate court action. It might take 60 to 90 days to do. Here's a referral. So they end up finding their own probate attorney, came back in about 60 days, closed the transaction. But needless to say, the family was not pleased with the realtor that none of that had been brought up because they had the property listed for several months and nobody talked about it. So the realtor has a little egg on her face that she didn't think about that ahead of time and maybe get that process going. So I always tell that story and make sure that realtors understand that if there are some red flags, talk to a professional who knows something about that, and maybe we'll get the guardianship started while you're working on getting the property listed. Saves everybody a lot of time and obviously makes you look good because you kind of, can curb those mistakes from happening at the closing table. Any questions about capacity? Yes.
If you had a power of attorney signed before she got into that situation, would it stand?
Good question. Would a power of attorney that was signed before she became incompetent stand? And there's a couple questions you have to ask. One is, when was it signed? And how do we know she was competent when it was signed? So a little bit would depend on the facts. Do we have any evidence that this was recent? Does she have a mental disease diagnosis? All that kind of stuff. Another question that you have to ask is, where is the original power of attorney? Because we have to record it in the county recorder's office prior to the deed. So we have to have the original. The power of attorney has to permit the attorney, in fact, to do self-dealing if it is granted to someone who also has an interest in the real estate or that would benefit from it. And it also has to be durable. A power of attorney must have a durability clause which basically says, this power shall survive my disability. Okay? Without that, it's not effective. And we've had many instances where attorneys have drafted powers of attorney and we've had to reject them. And of course, the attorney and the people who paid the attorney to do it get all up in arms, but it's pretty clear as day that we've got to have these elements, and not every power of attorney always does, because there is no standardized form for it. You can use a power of attorney for anything and everything, so there's not these standard provisions usually that people just kind of think they would have.
So notary won't cut it, right, Jonathan?
Right. And so the other thing about a power of attorney that has to be looked at is, will a lender accept it? So if it's on the buy side, okay, there's going to be a lot of scrutiny on that. And the question is, why do we need one? You know what I mean? What is the purpose of having one? There must be a really good reason in today's world why they can't, sign and wherever they are and ship docs back and that kind of thing. So lenders will want it to be specific to that transaction, specific to that lender. So when I've had those situations, I have a, kind of a template that I built where I insert the lender's name, the loan amount, the property address, and that this is being used specifically for this transaction, and this power of attorney will last, 90 days or 120 days, or until the completion of this transaction, at which point the power of attorney then terminates. So it's a limited use power of attorney. We do that all the time, especially if we have to appoint a realtor as power of attorney. It's a very specific, narrowly drafted document to make sure that it couldn't be misused in some way. Good question, though. Any other questions about that? Okay. All right. Let's get into the offer. So I mentioned earlier that you guys all have these nice real estate offer forms you fill out. That's great. But the basics are that an offeror must make the offer to the offeree with intent to contract. The offer must contain definitive terms stating the subject matter of the contract. And if you leave things blank, courts will fill in the blanks with whatever they think is a reasonable time frame, which is why the Columbus contract says, if left blank, this paragraph does not apply, or none if left blank, because if it didn't say that, you might have a problem with realtors leaving blanks and then courts saying, yeah, well, it's normal and customary in this area to have this amount of time in there, and so we're just going to imply that into your contract. You don't want that. So that's why the contract is drafted the way it is. All right, so the offer must contain definite terms, or at least state the subject matter of the contract. So what's the subject matter of a real estate contract? The property. I think I heard somebody say address, but the address is not enough. Okay, and that's what I want to get into is defining the property. What is the property? That's your subject matter. And if you don't define your property right, you probably don't have an enforceable contract because you didn't have a proper element here. Okay, and so most people would think, well, that's when's that ever going to happen? Well, it happens quite a bit actually. We see this all the time. And most of those situations, they don't end up in litigation, okay? People still buy and sell property all the time with bad contracts, okay? We usually fix a lot of those by pointing them out and saying, hey, I don't think your contract really covered everything here. What do we want to do? We work it out, we resolve it, we close anyway. But if something goes wrong, it's going to end up in court. And I had a couple examples, two that stick out in my head. I'll tell you about one of them, where this was about 3 years ago. And the real estate contract said the address of the property, okay? And it had one parcel number listed. Well, come to find out that the MLS had 3 parcels listed because it was a house and 2 vacant parcels next to it that were much smaller parcels and really probably wouldn't support a separate house. And so it was kind of like implied by the realtor, well, these would all go together, right? So they were kind of at the end of the subdivision and near a street. It was like forming a triangle. So anyway, the contract comes over. We do the search on the one parcel. Because why? Can you do a title search on an address? I'll tell you the answer, no. You don't search by address. It's irrelevant. Deeds used to not even contain addresses. It wasn't until the last 20, 30 years where most deeds even contained an address reference. Okay? Addresses are mailing addresses. They have nothing to do with the ownership of real property, and they have nothing to do with title searching. So the parcel number is actually something that we can then correspond to a legal description, and then we can search that because the way that searching works, you have to search it by the property and run it back grantor, grantee, all the way back to a deed older than 40 years. That gives us the root of our marketable title search, if you've heard of the term marketable title. And so, anyway, this definition of the property contained one parcel. So we did that search on the one parcel. We provided the title insurance commitment to the buyer, to the seller, to the realtors. Everybody had it. We get to closing, find out, lender actually does want to get a mortgage location survey. The mortgage location survey comes, shows the lot, everybody signs it at closing. They sign off on the commitment. And everybody closes. 4 months later, tax bills come out. And the seller gets 2 extra tax bills that they didn't think they were supposed to get. And so they call the realtor. Realtor then says, you got to call the title company. Title company messed up. Give them a call. Give them hell. They'll fix it. So I get the angry call from the seller saying we screwed it up. And I said, oh, I'm really sorry, well, that's okay if we did, we can fix that. That's not a problem. We can just do another quitclaim deed for those 2 parcels. If there was a tax proration issue related to that, I'll cover it for you and all that. So then after the call, I went and I researched the file and I was like, oh, geez, your contract is only 1 parcel. I don't know if you realize that. And they said, yeah, but the MLS had, the 3 parcels. I was like, yeah, but that's irrelevant. It's what's in the contract that actually matters. You can't go outside the 4 corners of a contract unless you have ambiguity. And there was no ambiguity in that. Therefore, you would never be able to introduce as evidence what was in the MLS in a court of law. So it's only when there's an ambiguous term that you're allowed to introduce extrinsic evidence. So anyway, I said, it doesn't matter, that's fine. We can still fix this. Just you got to do a contract amendment, right? Let's do a little addendum saying there was a mutual mistake of fact, and these other 2 parcels were meant to be included, and so therefore we'll fix it. I'll do a deed. We'll take care of it. Come to find out, after we did all that, we drafted everything. Well, Mr. ex-husband seller had moved to Florida. The reason they were selling was they were going through a divorce. And so the ex-husband said, I didn't like the buyers anyway, and I never agreed to sell the other 2 lots. So I want $10,000 for those other 2 parcels. So, needless to say, who would prevail in a court of law? And I had to basically tell them, I mean, hey, anything can happen, but in my opinion, your contract is not ambiguous. It has an address and a parcel number for the house, and that's what we've got. So you're going to have a real hard time, alleging otherwise that somehow there was the consideration paid included 2 other lots that you guys didn't put in. You could try and argue that. You'd have to, do mutual mistake of fact argument and all that. But the other side saying there was no mistake. So I don't know how you're going to win that. Anyway, come to find out, they all had to hire lawyers. We had to refer a firm out and say, hey, we were in the title company. You're going to have to hire counsel. We never got another order from that realtor. Obviously, they didn't like the fact that we sort of said this is how it is, and they kind of messed up. I tried not to throw anyone under the bus, but basically, I don't know exactly how that came out, but I can tell you that a year later, it had still not been resolved. And then I sort of lost touch with it, and I haven't looked it up. I think it ended up getting worked out, but one of those things. I'm sure people had to pay probably $5,000 plus to get that thing settled. So, define your properties clearly and correctly. And if you're dealing with multiple parcels, make sure you include all of the parcel numbers, okay? And if you're not sure, call up the title company and say, hey, we're working on this. I want to make sure this is right. Can you give me a second set of eyes? Can you look at the GIS maps with me? Whatever you need to do to help make sure you get it right. Question?
You can put in the contract, though, also referred to as MLS number, blah, blah, blah.
Okay, so the question is, can you include an MLS reference number? And that's a good question. I would tell you best practices would be to attach a printout as an exhibit and then reference the exhibit to say the MLS blah, 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 attached here to and incorporated herein. That would be the best practice way. That would be what a lawyer would do.
So put that on the contract that you're sending to the...
No, you don't need to do that. I'm just saying if there was some complicated, situation where you couldn't figure it out in the body of the contract, you needed to attach some lengthy thing from an MLS, then you could. But you don't need to do that every transaction.
I put that in mine. I won the class to do that, so I put the MLS number first.
Like I said, best practice would be to actually attach it to the document and not just reference an independent source. Could that source be changed?
Yes.
Yes, and that's why it's not good evidence. Because you don't have proof of what it was at the time that you drafted the contract, unless you print it and attach it. So you could still argue that it hadn't been changed. You could probably get the change log. You could probably go through that whole process to prove it, but that's why I said best practice. It doesn't open the door to the risk that your evidence isn't any good and could be defeated by good cross-examination. Alrighty. So that's the most important thing about the offer, is to make sure that you're defining the property correctly. We find that to be an issue when there are splits. So when a property is being divided and a new parcel is going to be created, that's oftentimes when you have a hard time defining it in the property. Make sure that when you say something like acreage, do not specifically state the acreage unless you are 100% sure that it is correct. Because you want to say approximately this amount of acres, because if it's measured and it's slightly off, now you kind of have a problem. You just contracted and agreed to give, 11.25 acres, but in reality it's only 11.1. You're a 0.15 acres short, so you're in breach. And so that's something you always want to say approximately and not be bound by that exact measure. We were talking about offers, okay? And I mentioned under the statute of frauds that the listing agreement and the buyer's representation agreements were not real estate contracts. They are agency contracts. You're representing someone. And so keep in mind that a listing agreement is not an offer to sell real estate. It is merely a contract that allows you to solicit offers to sell real estate. So they are different. Now, the next part of offers that trips a lot of people up has to do with the termination of an offer, okay? So how do offers end? Well, the most common one is lapse of time, right? Our form contract has in there the duration. The duration of this offer shall remain open for acceptance through this date. You guys fill in that date and time. That's called the lapse of time. The death of the offeree automatically terminates the offer. It's not binding on his heirs or anything like that. If the offer has not been accepted by the time the offeree dies, it's not acceptable. Incapacity. Okay, incapacity, we talked about earlier, same thing. If somebody gets in a coma and their offer is outstanding, you can't accept it at that point. Revocation and rejection. Revocation and rejection confuse people, so we're going to spend a little bit of time talking about that. First, before I do, I want to talk about what acceptance is. Acceptance is when somebody accepts the terms exactly as they were offered without modification of any type, okay? It's the mirror image rule, which I think, I don't know if I had that listed up there somewhere, but mirror image rule says that the acceptance must match the offer. You cannot change anything, closing date, home warranty, whatever it is. If you're changing something, you've not accepted the offer. And a lot of people think, well, I'm accepting it, but I'm changing one little thing. And then if the other side says, no, I don't really like that last little thing you threw in there, and they go, okay, well, we're still in contract on everything else. No, that's not how it works, okay? Acceptances must mirror the offer. If it changes in any way, it's not an acceptance. What is it? A rejection. It can't be nothing. It has to be a rejection. So when you counter offer, you have changed a term and you are rejecting the offer. Okay, so remember that. Offer, if it's countered, it's actually a rejection in a brand new offer, but the term counter more or less means the parties have switched seats from offeror to offeree. Okay, and so under the law, it doesn't matter if you're at counter offer number 1 or counter offer number 10. You're really at offer number 1 when you're at counter offer number 10. You're starting over every single time. And so when you think about it in that way, perhaps you'll be better at drafting your counteroffers. Because we see a lot of problems. I heard a laugh there. Yeah, I mean, we laugh at some of the counteroffers we see because who the heck knows what you guys really intended. And then the title agent is being asked to interpret that as to who's paying for what. But heck, I can't tell if counteroffer number 4 is accepting or including something that was in counteroffer number 2 that might have been rejected by somebody at that time, but now they're accepting. Who knows? So you've got to make sure that you clearly delineate in each counteroffer what you are accepting or rejecting in anything before it. Don't just be loose about it and think that everyone understands what you're doing, because they don't. And so you've got to make sure that the lender knows what's going on, the title company knows what's going on, the parties understand it, and more importantly, that there couldn't be ambiguity that later could blow up and cause your closing not to happen. Or, worst case, breach of contract, you end up in court and you have to defend yourself as to why you didn't, make it more specific. So keep that in mind. I don't have a great example off the top of my head, but there was one that I had to look at. It was 2 weeks ago, and I remember I was looking at it on my phone. One of our offices called me up, and basically there were 2 realtors arguing about whether or not closing costs were agreed to in the 3rd counteroffer, and I basically had to tell them they weren't. You know what I mean? I said, based on how you drafted it, you did not include this prior term, and so what are you going to do? You know what I mean? It was like a problem that we couldn't force the seller to pay these closing costs because it wasn't clearly in the final counteroffer that was accepted. Yes?
So every single counter, you have to say everything you agreed on before?
So if you have terminated or if you have rejected specific terms, in counteroffer number 1, you have 3 additional terms. Number them, 1, 2, 3. And in counteroffer number 2, they come back and say, we're okay with item number 1 and item number 2, but we're not okay with item number 3. You need to spell that out. and it needs to say, we're not okay with item number 3 in counteroffer number 1. Then in counteroffer number 3, they come back and say, okay, well, how about we list this new item and all other terms and conditions remain the same? That would probably be interpreted to mean that none of those items 1 through 3 are even in the third counteroffer, okay? Because it didn't say it. It said all other terms to remain the same, all other terms, but there were conflicting terms. So none of them apply. They knock each other out. So you have to restate items 1, 2, and all other terms would reference the pre-printed ones that weren't countered.
Oh, I thought it was the original.
No, it means anything that was before that you are referencing. So that's the problem, is that if you say all other terms are included, all other terms except for the ones that we already disagreed on, because you have evidence of that, which would go to the fact that you didn't have an agreement on what the facts were. And like this closing costs example, it wasn't in the third counteroffer. And the party had rejected that and changed the sale price, and so, you know what I mean? They basically agreed to the change, but their initial offer where they had the closing cost wasn't in the final one. So, you know what I mean? It's one of those fact patterns that I said, well, shoot, I don't really know what they meant in counteroffer number 3 because they weren't specific enough. Let's look at the other ones to try and figure out from an interpretation standpoint. And I basically said, look, off the cuff, realtor, this is kind of what I think you're facing, but I'll tell you right now, the fact that there's even a dispute between you guys means that we aren't making a decision either way. I'm not going to side with one of you. I'm not the judge. I'm not applying the law. I'm just telling you it's ambiguous. I can't tell. So you guys need to figure it out, get an amendment to us where you're both in agreement as to who pays the closing costs, then we can close.
Is it acceptable that once the addendums are going back and forth, and is it acceptable to write a new contract?
Sure, of course. Well, that question, is it acceptable to just write a new contract? Don't have everything signed and then write it new and just expect that you have 2 different contracts. You'd need to clarify that this is replacing all of these other documents, name them, offer, counteroffer number 1, counteroffer number 2 with this date, counteroffer number 3 with this date. This is replacing all of these with this new one. Okay, that's the best way to do it. But you can just redo counteroffer number 4, just do it on a new form. Do you know what I mean? Because they're all offers. You don't need successive 1-page counteroffer forms. Just say, crap, okay, we're getting too complicated. I'm going to go back and I'm going to put it on a new form, clean form. Just start over. There is nothing wrong with that. In fact, that's how I would recommend you do it. But the problem is that some agents were trained or taught or thought that they have to use these 1-page forms and they couldn't possibly go back and do a new form that makes it clean, and you have to explain to them when you send it over to them, hey, this is getting a little tricky. You know, we've always been told we get it past counteroffer number 2, we get into 3 or 4. We're just going to start back and put it on, you know, the initial form to make it easy on everyone.
The one that killed me was last week where I had someone say, well, what do you want the addendum to say? I can't go there.
Yeah. So when you have that situation where the parties don't even know what it's supposed to say and the lender's having trouble with interpretation, you know, they can't say, hey, lender, what should we put in this? You know what I mean? Like, he can't give legal advice and all that. Yes?
So that last counter you're talking about should state that these are the terms that have been agreed upon?
Yeah. So everything that was in the succession of counters that were basically rejections, okay, those items should all be respelled out every time as to what's in that current offer. If you're saying at the bottom all other terms and conditions remain the same, that would be anything that you didn't disagree about, right? But anything that you did disagree about or change needs to be restated in that final offer.
And then should you add in all terms of contract, purchase offer dated such and such?
Yeah, I mean,
You know that it's from that point on.
yeah, without having actual examples, it's kind of hard to answer that. But more or less what I'm saying is that counteroffer number 5 should state something to the effect of, purchase price shall be blank, closing costs shall be blank. Even if you went back and forth on those 5 times, restate them officially, this is it. So all items that you've been discussing are restated. That's the best way to do it, yes.
So if you never disputed it from the original original contract, you don't have to rewrite it.
Generally not, no, because otherwise you'd be rewriting it every time. So, if it was a standard boilerplate term that the loan contingency commitment date timeline was 25 days and you never countered that term, then that's what all other terms and conditions remaining the same really is getting at. So you never countered it.
Purchase price for the closing cost was never disputed, you don't have to keep on writing it.
Correct. If nothing was disputed, you wouldn't have to rewrite it. Because what is the counteroffer form? The counteroffer form is more or less an attachment to what came before it. Because in some areas of the state, if you don't know this, they don't use counteroffer forms. Okay? This is just Columbus uses counteroffer forms. Maybe Cincinnati, Cleveland do. But other places, they don't. They just rewrite a new offer every time. Or some places cross things out and initial it, which is even a worse practice. But I'm just saying, it's not all uniform. The fact that there is a one-page counteroffer form was designed to help you guys make life easier, but it gets misused all the time. So if you just think about that every time I'm writing a counteroffer, I'm actually starting over, writing a new offer. I could use the whole form if I wanted to, but that's a lot of paperwork, so I'm going to use this one-page shorthand, but make sure you're very clear about what you're countering out. Yes?
I've had a debate with various agents over the years where the counter offer is open until a certain time and date. And I've had some listing agents say that means nothing because we rejected your offer, and so when we can counter anytime we want to.
Correct. So, how this works is that the offer terminates by these items. So, a counteroffer terminates the first offer because it was a rejection. You cannot go back and accept it after you've countered it, okay? Even if it had a lapse of time provision. The lapse of time is like a default. If nothing else happens, it will terminate on this date and time. So a counteroffer terminates it earlier than the lapse of time. It can't terminate twice. You can't kind of terminate it or sort of have this contingent offer, and if they don't take that, I'm going to go back and accept the original one. It just can't work that way under the law. So the lapse of time provision confuses people in many ways, and I'm glad you asked that question, because the way that I've seen it be a problem, and I want to make sure all of you are aware of how to do this, is that when you are counter-offering, you are rejecting. So, do you need to do that prior to the termination of the offer via lapse of time? No, you do not. You do not have to have a counter offer within the lapse of time provision. There is no magical chain that is created by that. If you're going to reject it, you can offer them the next day. It doesn't matter. Right? There's nothing broken by that. For example, if somebody makes me an offer that says it's going to expire today at 5, and I'm teaching this class, I can't get back to them by 5 today, but I know my clients are not going to accept it. They're going to counteroffer. They're going to offer something else tomorrow. Legally, we do not have to give it to them by today, and they don't have to extend it. Okay? I can make that offer tomorrow. Or I can make it 2 weeks from now. Or I could make it 2 months from now. Or I could make it next year. I'm making an offer to buy or to sell, and I can make that whenever I want. The issue is acceptance. And then that's the legal issue. The practical issue is for you guys. The practical issue is if you don't get back to them, they will sort of move on, right? So what should you do? Call up the other side, say my clients are planning on making a counteroffer, but we probably won't get it to you till tomorrow. So just want to give you a heads up, that'll be coming your way. That is really what I would think is the best way to go, because they don't need to turn around and get something signed by their clients just to extend an offer that you're going to reject. It doesn't invalidate any contract, because again, counteroffer number 4 is an offer by itself, and that is the one that is accepted. And so that one was accepted within the right time frame of counteroffer number 4. It doesn't matter if that came after any sort of lapse of time in counteroffer number 3. Does that make sense for everybody? Yes.
As the offer, the initial offerer, if someone presented me with one-page counteroffer after the lapse of time, I'm within my rights to demand that they give me a full offer back.
Sure, if you're not sure what their offer is, you can ask them to rewrite the offer in a more clear language. You know what I mean? So, yeah. I mean, you can say, hey, can you put it back on a full form? But the idea of the counteroffer single-page addendum is to incorporate everything that was before it, which is why when you get to counteroffer number 4, it gets confusing. So the idea is that if I make an offer and I'm countering you with two items that I want to change, instead of having to retype the whole thing, I'm just going to use this one page, and it incorporates the other one to the back of it. So visualize it with pieces of paper. My counteroffer goes on top. It says all other terms and conditions in the offer below to remain the same, and I've stapled it on there. So now I've got all of them in it's one offer. It's just a slightly different offer than the original one. And the offeror and the offeree have now switched places. Yes?
I'm going back to, the counteroffer thing. Okay, so you get a counteroffer, because I'm kind of notorious for writing it this way, is I'll start out with, like the first counter. Thank you for the offer. We accept it with these changes. And then I list the changes, okay? Mm-hmm. So then the next counter comes back, and normally they followed my key, and they'll say, we thank you for the counter. We accept it with this change.
Right. That question is, we accept it with this change, and then the next counter says, we accept it with this change. That's where it gets very confusing as to what you have agreed to. It's not a very good practice.
Okay.
So, and also, you haven't accepted. So technically, you're saying the wrong thing. Because you haven't actually accepted with a change. You can't accept with a change. Legally, it's impossible. So you are counteroffering. And so you are agreeing to what they said. So instead of saying we accept, you would say we agree to all of these other terms and incorporate them herein, which is what the all other terms and conditions here, that's what it's talking about. We agree to all those and except for this. But if the first counteroffer said these two things and you came back and said this other thing, well, you have rejected those two things, right? They're out because you did not agree to those. But if you said we agree to everything but this one change, now we have a question. It's like, well, did you accept those two changes because this other one you did was different? It just leads to confusion. So you should say, we accept all other terms and conditions except for item number 1 in your counteroffer number 1. But we accept counteroffer item number 2 in counteroffer number 1. Does that make sense? You just are very clear about which items you're accepting and which ones you're not. Then there's no ambiguity, there's no question, and it's just best practice. There can't be any misinterpretation down the road. And like I said to start this conversation, oftentimes you guys all have closings with counteroffers and with contracts that may or may not have been accepted correctly or may not have ambiguous terms, and nobody's ever really harmed by it because the parties generally think they know what they agreed to. But the problem is when you get a dispute because it wasn't clear and it was about a significant term, and then the title agency is being asked to do the interpretation by both sides. Hey, agree with me, agree with me. Title agents should not be doing that, and they should be saying, if there's any disagreement, that means we have an ambiguity in the contract. That means that you guys have to do an addendum to tell us what the agreed term is, because we aren't going to move forward without joint agreement. Okay, any other questions about that? Okay, so I mentioned acceptance already. Let's get into, sorry if you saw that. All right. These fact patterns, if you saw it, then you'll know the answer. Don't speak up. Buyer submits a written offer to purchase a house for $200,000. Offer states that it will be open until Monday. While seller is making up his mind, buyer finds another house. So buyer's agent calls up the listing agent on Sunday and revokes the offer verbally. Seller then signs and accepts the offer in writing, and the listing agent emails it back to the buyer's agent. Why did they do that? Because they were like, oh crap, I never told him that he told me it was revoked. I didn't get anything in writing, so we'll just go ahead and accept and we'll see what happens. So the question is, are the parties in contract? So if you didn't see it, you might think yes, but technically the answer is no, because the revocation was communicated prior to the acceptance. Okay, so the acceptance had not been made and the agent knew that it was revoked. And so technically, theoretically, we have a situation where the knowledge of you, the realtor, is imputed upon to your client, and therefore your client cannot accept an offer that they know has already been revoked. It's a nullity. But how would you prove that, right? So the question is, does your answer change if the selling agent leaves the revocation on a voicemail for the listing agent on a Sunday, and prior to the listing agent checking the voicemail, they submit the acceptance via fax on Sunday to a fax number that isn't checked until Monday, right? Because that's what happens in the real world. So can a realtor avoid the knowledge by not checking their voicemail? Well, I didn't know it was rejected because I didn't actually listen to the voicemail, right? So I have no knowledge that it's rejected. But then I sent my acceptance, but they didn't check it until after the lapse of time provision. Anyone want to take a guess about that? What's valid, the revocation or the acceptance? How many people say revocation? How many people say the acceptance? How many people are just confused?
Isn't that kind of like knowing you got certified mail but didn't accept it?
Yeah, I mean, kinda. You signed for the certified mail, so obviously you've got constructive receipt even if you don't read it, right? So part of the way that the body of law works is we're saying that the revocation was communicated prior to the acceptance being sent. And what we're talking about here is the mailbox rule, okay? And I know with TRIB we've heard about the 3 days. That's not really the mailbox rule, right? The mailbox rule says, this is an old concept dating back to the 1800s, that when an acceptance is sent in the mail, it is effective as soon as it has been sent, okay? So if the revocation was not known by the person doing the sending, then they thought in their mind they were having genuine assent to 100% of the terms, mirror image rule, and that they made the acceptance in the manner in which it was specified, if acceptance was specified in the contract, which your form does not do that, but it could. Commercial contracts, attorneys would write that in. But anyway, the acceptance of the terms must mirror no modification, and when it hit the mailbox and the flag goes up and is properly addressed and properly stamped, that acceptance is valid. Doesn't matter when the recipient receives it. The acceptance trumps, okay? So that's kind of the moment in time in which acceptance is valid. So the contract specifically identifies it must be delivered, i.e. must be sent. And so if you send it via electronic communication like email and you hit send, that's probably the moment in time in which it is sent. Because the example there would be you as an agent cannot avoid opening your email for a week because you don't want to be bound by someone's acceptance. You can't avoid that, you can't ignore that. So that's why they have that rule. So what happens if you make a typo in the email address if you're going to email a signed contract and send it to the other party? Do you think it's accepted?
No.
Anybody say yes? Okay, everybody said no, yes. I would agree with you. Is that if you make a typo, you did not send it to a place that they could even receive it, and therefore it's not valid. It would have needed to be properly addressed, more or less, is what we're saying. So if you're corresponding with another agent, it happens to be all via email and not .loop or one of these other platforms, make sure you send it to the right location, follow it up with a phone call if you need to, whatever. But keep in mind, you could make a typographical mistake and you could cause the acceptance to not be valid. Any questions about that before we move on? Okay, so I'm going to, due to time constraints, kind of skip through some of these things. Consideration is something of value in real estate. It's the purchase price. Enough said. Let's move on. Lawful purpose. We've already talked about that. We don't really need to get into liquidated damages. Options. All right. Right of first refusal versus an option. I get some of these from Southern Ohio from time to time. In fact, I'm working on a right of first refusal right now for somebody out of our Chillicothe office. So it does come up. And I think that a lot of people don't understand the difference between a right of first refusal and an option to purchase. So I'll just touch on that briefly. An option to purchase is something that is in favor of a buyer who can choose to exercise the option or not exercise the option based on the timeline and the agreed upon terms that were drafted into the option itself. So it would say, I have the option to buy this piece of property for $100,000 on or before this date, supported by separate consideration of $1,000. Basically, the $1,000 makes that option enforceable and keeps it open and prevents the other side from revoking it or terminating it in any way. So it has to have separate consideration to be enforceable. And so that's what an option is all about. You might have a lease with an option to purchase, right? They're leasing the house. They have an option to buy it at a certain price during the term of the lease. And so they've already agreed to the price up front. You know all the terms, and it's just a question of will they ever exercise it. A right of first refusal is a little different. A right of first refusal is often used when a person sells property, splits off a piece of their land, and somehow reserves unto themselves some sort of right, or grants some sort of right, I should say, to the buyer. So in the situation I'm dealing with right now, that's what's happening. You have a buyer and a seller who they were in a contract, and this is where it gets tricky. The realtor wrote into the contract, buyer shall have a right of first refusal on any remaining acreage of the seller. So then they came to me, said, Jonathan, can you draft that right of first refusal for us? Closing is Friday. This is Wednesday or whatever. I'm like, oh, geez. All right. So you weren't very specific. Okay. So that's problem number one. How do we know how this should work? Because I talk with the buyer, and the buyer's like, I can't buy all 270 acres that are the remaining parent parcel. I couldn't afford that. So I only want 10 acres. And then the question is, well, if you only want 10 acres, but we don't have a legally defined 10 acres, we aren't going to have an enforceable right of first refusal. You really can only take that right on an existing piece of property at that time, which would have to be the entire 270. And so basically we ran into a problem because they were in contract, and of course they said, well, we agreed to it in the contract. And I said, unfortunately, you kind of really only agreed to the fact that you'd have the right to buy the rest of it, not a portion of it. And if we were only going to do a portion, you'd actually have to go hire a surveyor to draft the boundary for that, because we don't know what land you'd have the actual right on. So when the seller 5 years from now goes to split off that property, we're going to have an issue that you're not going to be able to close, because they're going to argue about where that right should exist. Long story short, the right of first refusal is something that grants a person, and it's kind of like granting an option, but it's granting a right to stand in the shoes of a true buyer. Okay, so an independent third-party buyer comes along and says, I'm going to buy this property. I'm making an offer to buy it for $100,000. And the person who holds the right has a certain amount of time to exercise it, say 30 days, where they can say, I'm going to replace that buyer and that $100,000. I'm going to take it from them, and I'm going to buy it from you for that same amount. Okay, so an owner of a property that has a right of first refusal on it cannot accept any offers, okay? Because accepting that, they'd be accepting it subject to the fact that someone else could come in and trump the buyer's rights. So that would be a problem. So anytime you have a seller with a recorded right of first refusal, you've got to be careful. We've also run into some problems with rights of first refusal where there wasn't clear indication of what happens if they didn't exercise it. Right? How do we know that they provided evidence to them that this existed, and you have these recorded rights of first refusal out there, and you don't know if they were ever met? And so, it's draftsmanship. You got to make sure you've got something very clear. And I've had to tell people, and tell realtors in real estate closings, unfortunately, we have this title defect. We've got this outstanding right of first refusal that's never been resolved. It was there for 30 years ago, but we don't know if that's ever been waived, because nobody ever recorded a termination of the right or a waiver of the right. Okay, and that happens a lot. So, you've got to have good draftsmanship that says, what's going to happen in the event of the fact that they decline it, right? They don't want to exercise the right. So that's something that you might run into someday, and will throw your closing, and it'll come to a screeching halt for a while until you get that resolved.
Right of first refusal, do they have to record that then? It has to be recorded?
Oh yeah, if it's not recorded, it's not enforceable.
Can anyone just do that and say, I'm going to
No.
this place
No.
on this property?
No. It has to be granted by the owner of the property to someone to have a right for future sales. Yeah.
But if they have a piece of paper signed by both parties in a safe in their, basement or whatever, and they pull it out, that is not valid if it's not.
If it's not recorded, it is not valid for bona fide purchasers for value, which mean people that would have no knowledge of that and paid consideration for the property. So a buyer who was in contract, closed it, and then all of a sudden somebody came out waving this piece of paper later saying, I had that right. Okay, too bad. You never recorded it. Nobody was on notice.
So that would be, the seller would be unethical, but not against the law if they.
Yeah, it would basically just be ineffective. So if a seller granted a right of first refusal to, let's just say Mary granted to Joe, okay, and then Joe didn't record it and kept it in his safe, okay, and then Mary sold the property to Bob, okay, and then Joe sees the transfer records that Bob is now the owner of the property. He calls up Mary and says, what the heck? You gave me that right. Why didn't you tell me? And his remedy then would be to what? Sue Bob and Mary? He's never going to prevail against Bob. Right. Bob has insurable title to the property because it wasn't recorded. So Joe's only remedy is to sue Mary for breach of their contract for granting the right of first refusal because she didn't notify him that she got an offer. So his remedy is going to be limited to damages only. He's never going to get the property because a bona fide purchaser for value came along without notice. Hopefully that explanation made sense. I'm trying to go fast because I know we're going to run out of time with this section.
If someone executes a lease with the right of first and continues to try to sell the property and executes a right of first refusal on that lease and then records the memorandum of lease, is that enforceable?
If the memorandum of lease makes mention of the details of the right of first refusal or the option to purchase, most likely, yes. Because the world would have been on notice that such a right exists. And so sometimes the sufficiency of that may be in question and may be arguable, but in general, I'd say yes. Okay, so let's skip through. Oh, mitigation damages, one thing to note about that is there is a legal concept called the duty to mitigate. So if you have a buyer and seller that have a fallout of their contract and they breach, okay, and the seller is mad that the buyer didn't buy because the buyer breached, the seller has a duty to mitigate their loss and relist the property and try to sell it. They can't let the property go into a state of disrepair and then abandon it, and then the copper gets stripped out of it, and then sue the buyer for all of that loss. Because the court would say, I'm sorry, but at the time of the breach, none of that happened. So everything that happened after the breach is more or less your fault because you didn't mitigate your loss. You did things or didn't do things that caused you to exacerbate your damages, and you're not going to be eligible to recover that from somebody. It wasn't their fault. So it's usually about foreseeability and that kind of stuff. All right, listing agreements. So to touch on this real quick, this is a type of contract, right? A listing agreement is a contract, but not a real estate contract. It's a services contract. And so you could have the exclusive right to sell, which is where the brokers paid a commission on anyone, being a buyer. You bring anyone to the table. There are also other types of agency agreements. An exclusive agency agreement is where if anyone other than the seller finds a buyer, a commission is earned. But a seller could still go find a buyer. So notice yours will probably all be exclusive right to sell. That's what it means. Open listing is more or less where anybody can bring a buyer, and whoever brings the buyer gets the commission. Okay, that's what an open listing is all about. All right, so real estate related disclosure forms, okay? Part of your contractual duties under a real estate contract in Ohio is that you've got to provide the residential property disclosure form pursuant to Ohio Revised Code section 5302.30. And I've quoted some of the provisions here. Except as provided in B2, which is down here, This section applies to any transfer of residential property occurring after July 1 of 93 by sale, by land contract, by lease with option to purchase, by exchange, or a lease for a term of 99 years, renewable, and for purposes of this section, a transfer occurs when the initial contract for transfer is executed. So the signing of a land installment contract triggers the need for a residential property disclosure form, and the signing of a lease with option to purchase also triggers the need for that form. Now, when do you not need the form? You don't need the form when a transfer is pursuant to a court order, a deed in lieu of foreclosure, a deed to a trustee by a trustor, so basically someone in and out of their own trust or between, trustees. The foreclosure of a property doesn't require that. A sale under a power sale under the power of sale in a will, that doesn't require anyone to produce that. Between co-owners, so if they already have some sort of interest and you're transferring the rest of it, you don't need a disclosure form then either. Any governmental entity selling property does not have to provide the form. And then newly constructed homes that have not yet been inhabited, you don't have to have the form. So all other transactions, you have to have them. And usually I get a question that says, what about REO? Well, if it's owned by a lender after a foreclosure and the lender is selling, that's not an exception under B2. So the REO company, the lenders, needs to provide a disclosure form if they want the protection that it gives. Now, what happens is that if they don't do that and they don't provide a form, what's the remedy? Okay? It goes on to say that failure to provide the form to a buyer without an exemption will permit the buyer to walk away from the contract up until the moment of closing or 30 days from the date of the contract. So if an REO company does not provide the form, okay, what's the buyer's remedy? Well, they can get out of the contract by state law. They don't have to go forward. But if they choose to go forward anyway, well, then that's what they do. The purpose of the form is to understand what the knowledge of the seller is. And the REO company probably has no knowledge of anything anyway. They may or may not have ever even been there. And so you may have a problem with getting any valid information anyway. But the statute says that a transferor, i.e. a seller, is not liable in damages in a civil lawsuit, okay, for injury, death, or loss that allegedly arises from an error or inaccuracy or omission of any information that was disclosed in the form if and this should be capitalized and italicized, if the error, inaccuracy, or omission was not within the seller's actual knowledge. So just because the form didn't disclose something doesn't mean that if you find that to be false, that you can sue the seller and win. You can't. You have to prove that they committed fraud. And in order to prove that they committed fraud, you have to prove that they knew and they lied. They made an affirmative statement that lied, or they concealed the information. So in a lawsuit, using the disclosure form as your basis for fraud, you got to prove that they, more or less had knowledge. And how do you do that? How do you prove someone has knowledge? That's difficult to do. We'll get into that here a little bit later when I get the case examples. Okay, so other things you have to do. We talked about the lead-based paint form earlier. You've got to give that on all transactions where residential dwellings were built prior to 1978. The Ohio agency disclosure form issued by the Department of Commerce is required to be presented to a consumer prior to signing an offer to purchase or to lease. And then the Consumer Guide to Agency Relationships is given upon first contact and explains agency to the consumer, but I also recommend you read it. If you haven't, make sure you understand what it says.